Fresh admission.
Whatever, sir. Fresh admission orders, then after notice, call page wise. Call karo.
Rookie list page 1 to 9.
10 to 15.
Let's see item 1. Let's see.
1. Wait. Item 1, you have to wait. What after?
Another item also, let's see. Item 33, let's see.
No, not that way. You are not following. You are absent-minded. I should be absent-minded. No, not
Item 10 to 15.
Your Lordship, item number 3, praying for adjournment.
Please, wait. Fresh admission will reaching, sir, immediately.
Page 3, 16 to 21.
Item 16.
So the mentioning of adjournment, when the matter is not likely to reach. Since I am also granting in fresh admission, you request your friends, you can leave the court also. Well, I have now, since at least I have allowed the mentioning in fresh admission, which I should not have. Yes, next.
Page 16 to 21.
Item 16, my lord.
Yes, sir.
Though the notice was issued, my lord, but the opposite not till not appeared, my lord. Let it next week or any other day.
Sir, judicial order I am not passing, it's simply posting. You want posting? Posted. Yes, next.
Your Lordship, item 27. Seeking for
Page 16 mention kale. 16 kale na? Again, my lord.
Page 4, 22 to 26.
Item 20.
Page 5.
Lordship, item number 25.
Posting another day.
Yes, Lordship.
Record you.
Interim order is there.
No judicial order out of turn. No, simply posted. It remains untouched. Whatever is there is there.
Will commence in nothing.
Yes. Interim order, if it is vacated today, then you have to wait for your turn. I can't give you a preference. You have to wait for your turn. I'll see. Then I'll. In simple adjournment. Obviously, I am not touching any interim order. Be assured of that.
Your Lordship, item 27.
Yes, please.
Seeking for an adjournment.
Another date for the next.
Item 30, my lord. No, item 30, my lord. I'll file
30. Yes.
Yes, my lord. I'll file result.
Date कर दियंतु.
Will commence.
27 कले.
Okay.
टीटी कहि दउथांत आपण जो कहू नांती से भाबुचन जे आपण माने यू आर नॉट रेस्पॉन्ड. हां जल्दी.
Item 33, Lordship.
Yes, टीटी बढ़ांतु.
Praise for an adjournment, Lordship.
ठीक अछि 33 करन.
Lordship, item 28. Item 28, my lord. Item 28. Next week.
Proceed करन. Yes.
Item 35.
Yes. What adjournment? ठीक अछि.
Will commence in floor.
Yes.
Item 29, my lord.
Yes. Adjournment.
Okay. State is supposed to file a counter.
Well, if you want any judicial order, please go.
Oh, bless you.
Let them kindly note whenever there is a order directing for filing of counter, please mark that. Mr. Lenka, Mr. Bhanti is mentioning 29 counter not filed. So please mark it in your brief or list, whatever you are marking. The counter to be filed, you have to file counter. Yes, next.
Oh, bless you.
Page 6, 36 to 31.
You want 37 or item 3?
Item 3.
Just take your seat. 36 to 41. Yes.
Item 1.
That's item 1, Lordship.
Please.
Praise for an adjournment, Lordship.
Yes, posting कर देंगे एक टच.
Will commence in 16.
16 दिन हबो तो. Obligation. के बस रेस्ट आगो को रखिबे. माने मु जानि आपण केते लेखा
Item 16.
हिसाब करछन्ते हो केतरा पोस्टिंग करछन्ते हो ठीक अछि. 2 तो जेना पासवर 3 adjournment की मांग
Two, my lord, 2.
अच्छा 2 ठीक है. मिस्टर परिजा.
My lord. May I please?
तो BC परिजा for the petitioner. Yes.
My lord, the present petitioner is the son of the opposite party.
Yes.
The opposite party initiated a case under section 125 for maintenance. Here the law and court below after
Right. Handicap.
no, my lord. Handicap no, but as there is some misunderstanding between the mother and
Ujipami. Who is liable to maintain whom?
son is liable to maintain mother.
Correct. 65 years old.
My lord,
So I got it right.
the mother-
70 and 48.
my lord, my submission is that the mother had 2 sons, 1 daughter. His
Which
eldest
provision? Which provision of statute? two sons, one daughter, that can
It's
be
my,
maintenance.
no, my lord, it's my duty to maintain.
I'm not asking you duty. Duty and fundamental rights, that's a different chapter altogether in constitutional. So whether there is a personal right to maintain, that's not also there. I'm not very sure. I have not read that way. But there is a mandate of a statute that the mother is likely to be maintained, especially aged mother at the age of 70 years.
My lord, I am ready.
So
but,
she is also ready to accept. Both are ready. So why the court?
no, my lord, I am ready to maintain my mother. But she is maintaining, she is claiming for money in maintenance, which is
This provision that she cannot claim, sir. You go, let us not have a drawing room discussion. I will invite a cup of tea. All of us will have a cup of tea. That should not be the approach. We are watched in YouTube.
my
What
lord.
you are submitting, can I pass an order that an elderly mother wants money? The two children and the person who has, you have to you have to first deny your liability. Second, quantum, then you have to make out a case. What is your pleading before the court? Even denying liability.
I am not denying. I am not denying.
Then what this appellate court will do?
But I am not denying.
Ready to pay, she is ready to accept.
My small submission is that the amount which
Sir,
is.
take submission in accordance with law.
Well,
You do not like to give money or maintain your mother. I have no personal issues there.
well,
But legally, I have to take a legal view. Sir, that is how I said that I have not read that there is a fundamental duty towards the state. There is a chapter fundamental duty. So there is no such chapter fundamental duty of children to parents. So whether they maintain or not, it is their choice. But if there is there is a provision, so legal provision. This is not the forum to discuss all these things. How many children and all that. That is before you have to make suitable. There has to be some provision in the law. If there are 3 children, the son willing to maintain, but no money will be given. Cite that provision.
I will go through that.
The petitioner son is before this court, challenging the order dated 22/01/2024, passed by the learned judge, Family Court Bhadrak, in CR.P. number 149 of 2019. Stuff. The said application was filed by the petitioner's mother, who is now aged about, who was then 65 years and now is aged about 70 years. It is stated by the learned counsel for the petitioner son that the petitioner is willing to maintain the child, maintain his mother aged 70 years, but is not willing to pay any money.
My lord, as per my standard, maintain as per my standard.
Sir, you have to take that plea. It's a matter of proof and evidence.
Needs well.
So that standard, where they show the written statement. What is the
It is the observation of the learned family judge that
according to proof? He is not a party to the litigation. He cannot be. Judge cannot be a party to the litigation by adducing evidence. So Parijat have to. Let us not flounder like this. I ask you evidence. You are saying the learned judge. You have to say the petitioner adduced such and such evidence. This is his statement. Cross-examination of the lady is like this. There we can't flounder like this. Willing to pay money as directed by the learned court. Learned family court. That is at rupees 2,000 per month. On being asked what was the evidence adduced by the petitioner before the learned trial court, learned judge family court, to support his contention that the petitioner will not pay 2,000 when the mother had claimed rupees 20,000 per month. The learned counsel for the petitioner seeks and has adjournment or I'll dispose of. Adjournment or dispose of?
My lord,
You have a choice.
I'll go.
2000 पे आपण कोण adduce करतील evidence? You are okay.
My objection.
So you are tentative. Let us not spend time there. Whether you will seek, you take adjournment. That would be in the safer side. 6 and has adjournment. केते समय चाहुचन? Sir, when you are filing an appeal, sir, you should go to these basic things.
2 weeks.
Otherwise, what the appellate court will do?
2 weeks.
If the court is not considering any pleadings, not evidence, points of questions of law, or whatever issues framed. कौन लेखी दी सप्ताह पर रखी दियो मार्च मास चाहते ଆପଣ 16/3 କେତେଟା ମ୍ୟାଟର ରଖିଲେ ଆଜି ଆପଣ କେତେଥର ମନା କରିବେ ଯେ 16/3 ରଖିବେନି ବୋଲି 16
Item 3,
3 adjournment. Yes, next.
item 4,
Yes, please.
My lord, yesterday I got the instruction. You lordship may give 2 weeks time to file.
Mr. Ranjit Samal for the petitioner, Mr. G.N. Leka for the opposite party. Lord AGA submits that he has received instructions in the matter
Yes.
as directed by order dated 4/12/2025 by the coordinate bench. So, it is submitted. Further 2 weeks time may be granted to obtain further instruction and file affidavit.
Yes.
Accordingly, the matter shall be listed in the week commencing 2/3/2024. Yes, next please.
item 5,
Mr. Saraswati Senapati for the petitioner.
Petition seeking a direction to transfer the maintenance proceeding which is pending
And,
before the learned
look
judge.
at 145. This is 125 or
Lordship consider it.
the statutory, there is a statutory mandate of initiation of the proceeding. The court's hands are tied as far as maintenance is concerned.
It's a consider an
So look at
alternative.
155.
Yes, Lord.
The only thing I'll dispose it of only that if you want ICT, all these things, that direction I'll issue. Okay.
Lordship may consider any alternative mode of appearance. Base.
You are not referring again the same problem, madam. I discussed so in detail with Mr. Parija. You have to give me some provision which enables the court to do these things. 145 Bharatiya Nagarika Suraksha Samhita is specific where the proceeding shall be initiated. There is a purpose. That you must appreciate. I can't close eyes while looking at reading 144. I can't close my eyes when 145 is if I know by chance I glance. Can I? Then I have to record that I'm closing my eyes to 145. I'm transferring it to the place of my choice.
Lordship may consider to appear.
Of course. Whatever your requirements, but you have to move that before the trial court. Suppose the
Yes.
trial court is not allowing you, then you can challenge that also. I mean, 125, one for what's your order for similar disposed of. Say 125 CRPC or 145 DNSS. You decide. Order such. Yes, next.
item 6,
May it please your lordship.
Yes, please.
The petitioner is the wife. The husband has got a divorce decree for divorce. Ex parte. Your lordship will kindly see.
You have not challenged ex parte decree on that?
Yes, CMA is there. Now she is seeking transfer of the case from Cuttack to Raurkela.
But the problem is that this I have been discussing with that upon restoration another court will consider. Till restoration. I hope you understand what I am saying.
My lord. No,
The court which proceeded ex parte,
my lord.
Order 9 Rule 13 will be considered by the other court. Another court. That you are saying. So that I have been seeking your assistance. Please examine that.
My lord,
I have requested to Parija or Mr. Sahoo or somebody.
I understand your lordship. I understand. Yes.
I think simple. I mean, what you call that interpretation of the
The lordship
CPC.
judge whether it should be done by the same judge when he is sitting,
No.
still sitting.
Not only that, same court also because
Same court.
matters and evidence, everything is there. So Order 9 Rule 13, if it is restored,
My lord.
then whether it should be considered Order 9 Rule 13 should be considered another. So Order 9 Rule 13 has been filed before the self-same
Same court. It is
Self-same
pending.
court.
It is pending.
So after restoration at the stage has to be there.
My lord, yes, I
Please
will.
appreciate one thing also.
I will
Suppose
examine-
now restored. It will go to the stage where it was left.
My lord.
But if it is transferred, it cannot be restored to that stage. Another problem. There are so many issues. And right now, I mean, I would like to enter into open-ended discussion with you.
My lord.
But let us, you come back. I hope, but I have not remembered the other case. I could have tagged both the cases.
My lord. 3rd week of February.
Yes, kindly leave 16 to 20, then
My lord.
3rd or 1st week of March, whatever
First
you
week
like.
of March. First week of March.
Welcome, sir.
Mr. Masudev Pujari for the petitioner, opposite party blank. The petitioner wife is before this court seeking transfer of the petition filed by her. That is, then CMA na ta number ta kitna?
CMA is number
19 of 2026. Oh, CMA.
CMA 60 of 2025.
CMP na kaun tha?
CMA is 60 of 2025. Page 5 of the brief, page 6 of the brief.
CMA number 60 of 2025. Stop.
ये तो 24 है।
Pending before, and just family court.
Judge family court कटा।
That the said CMA arises out of the said CMA has been filed under Order 9 Rule 13 of the CPC for setting aside of ex parte judgment dated
CP number 543 of 20.
2020.07.2024 in CP number 543 of 2023
My lord.
disposed of by judgment dated 20.07.2024. Para. The learned counsel for the petitioners shall address on the point whether upon restoration, for restoring the matter, for consideration of Order 9, for consideration of a petition under Order 9 Rule 13, seeking restoration, the matter can be transferred to be considered by another court, which apparently did not pass the ex parte judgment and decree. Yes. Least in the week commencing.
My lord, IA is there.
Rubbish.
Unless an interim order is passed, he may proceed. You said that I will proceed. So IA may be.
But Order 9 Rule 13 is in your interest. That will be a conflicting order passed by the appellate court. Please appreciate.
She is unable to pursue the matter here. Your lordship may say the
Only adjournment.
yes. If I file a petition,
Because
if I file a petition,
because this I find very difficult. I mean, the person who seeks restoration, I will adjourn. I
may say
no, I have to.
if I pass,
If I
file a
seek to
petition,
appear. Yes.
file a petition,
To a suitable date that will be available to her beyond 2 March 2026 upon an application
Ma'am.
being made on that day
Ma'am.
for that making such prayer.
Item 7,
My lord, I have challenged the order dated 30/12/2025 passed by
This is
the,
my determination.
my lord,
Prayer pertaining to
my lord. The two
which act? Which act?
copy there is.
Copy nahi?
Copy has not, file has not come, my lord. Copy
Sure.
my lord.
File type. But ଆପଣ ଦେଖି ଦିଅନ୍ତୁ ସେଟା ଏବେ but whether it is in my roster or not.
Yes.
କୋଉ
It
subject
was
କହିଲେ?
listed in court number 12.
ନାଇଁ ମୋ କୋର୍ଟ ନମ୍ବର 12 ଯୋଉଟା ନାହିଁ ସେଟା ମୋର ରୋଷ୍ଟର ନୁହଁ
Nahi,
ମୁଁ
seti-
ସବଜେକ୍ଟ ମ୍ୟାଟର ଡିଟରମିନେସନ ପଚାରୁଛି ଲିଷ୍ଟେଡ୍ ଇନ୍ କୋର୍ଟ ନମ୍ବର 12
no, no, it is under Society Registration Act. It is your lordship's assignment.
ଭଲ କଥା ମୋଷ୍ଟ ୱେଲକମ୍ କୋର୍ଟ ନମ୍ବର 12 ସେମିତି ହୁଏ କି ଯେତେବେଳେ ଆପଣଙ୍କର କୋର୍ଟ ହୁଏନି ତ କୋର୍ଟ ନମ୍ବର 12 shall not function and the matter shall be
No,
moved
no,
for court.
my humble submission is it was listed, but this is,
ସେଇଟା ଆପଣ
their lordships directed for verification by the registry.
asking sir I'm not asking sir
After that,
unless you answer a simple question you make you have said I take it that Society Registration Act serial number
12.
yes, my lord,
That's
serial
the
number
answer.
12. No, assignment was not with me.
serial number 12
Serial number 12.
yes next
I'll solve the copy in course of the
yes,
day.
yes.
And your
It is
lordship.
submitted by the Honorable AGA that Alok Kumar Ponda for the petitioner, Honorable AGA for the opposite party. The counsel for the petitioner submits that the Honorable AGA submits that he has not received the brief.
Yes.
The Honorable counsel for the petitioner shall serve another extra copy. The Honorable AGA during course of the day. During course of the day. List kebe.
My lord, this matter may be listed along with WPC number.
Seda eta hela pore. Mu take up korini tapore
Then tomorrow. Then tomorrow.
Tomorrow hai pariboni. Day after tomorrow. Day after tomorrow hai chibo. Subject.
ଆପଣ ଦେବି ନା
Update. Buधବାର ଦିବସ ହଉଛି ପତ୍ର
item 8,
May it please your lordships.
Yes.
The present petitions, my lords, is assailing the appointment of opposite party number 8 as the fair price shop dealer, my lords, for the Puneshwari Basti, my lords. That is the area.
Petition, that order is displayed, page.
My lords, page 20. Page 20.
Yes.
There is an RTI information. My contention, my lord, is that 6 people participated. And after participation, our documents were verified and all. After that, there was no response from the office of the ADM and otherwise. So when I applied under the RTI Act, I came to know that they have already selected a person and given it. So after the application under the RTI Act, only I have come to know. And on the date of verification also, I have alleged that also that on the date of verification, the present opposite party number 8 was not present.
So you are challenging selection of a dealer of a particular area.
My lords.
You have a competing claim.
My lords.
As a citizen.
No, my lords. I was one of the person who was in consideration.
SHG group.
SHG group.
Appeal.
My lords.
Appeal.
Appeal, my lords, is not there. This is a fresh guidelines which I've come across. I've given the guidelines as well.
This is not covered by OPDR. OPDS.
I'm not.
Control order.
No, my lords. This is the
19 account ADM.
ADM.
2016.
2016. देखो
I am verify. Verify what is wrong.
Open-ended discussions are always no difficult.
Check, cross-check, but I may be wrong also.
No, I mean there are. I mean, rather you can say complete power.
My lords.
The lordship may see the order 4, page 50.
APS, this is APS, fair price shop.
My lords.
Sir, yes, Mr. Lenka?
Yes, sir. Appointment dealers and grant of license, order 4, my lord.
Order 4?
Yes.
I'll borrow.
Chapter 2.
I have an old.
ଆଉ ନାହିଁ ଆପଣ ୟାର ଆପଣ ଚାଲିବା ପୂର୍ବରୁ ନିଅନ୍ତୁ ଏଇଠୁ ବୋଥ ଅଫ୍ ୟୁ ରିଡ୍ ଆପଣ ଏଠି ଆରେ ଆପଣ ଏଠି ଆସନ୍ତୁ
Page
ଯୋଉଟା ମୁଁ କାଢିକି ଦେଇଛି 16 से देख रहे हैं, रेफर करें 16.
My lords. Page, the clause 4, my lords, order number 4, my lords. Here it is stated that appointment of dealers and grant of license. Dealers shall be appointed by licensing authorities by following such procedure and in such manner as have been and may be prescribed by the state government. No dealer, clause 2, no dealer may be granted a license under this clause unless he has been appointed as such by the licensing authority under subclause 1. 3. Preference for appointment and for grant of license, a dealer shall be given to the Gram Panchayat or the urban local body, as the case may be, followed by women's self-help group, cooperative society, and other self.
So it is there, 4 there, that don't kindly take appeal.
Yeah.
19. What actually support for each other?
Appeal is not there.
Appeal even though there is a provision under section order 19, my lords, by the licensing authority, refuse to grant or review.
Can you refuse to grant?
Again.
What would be the interpretation?
My lords, that of course, if I stretch it through, of course it would come.
No. And the problem is that there are A, B, C, D, E, F.
My lords.
5 applicants.
My lord.
There are competing claims.
Yes.
He is the right person. Refuse to grant, please read. Please read.
My lords, I'm placing, my lords. 19, appeal, clause 1. Any person aggrieved by an order of the licensing authority refusing to grant or renew or reissue a license or suspending or cancelling a license or forfeiting the security deposit or withholding the allocation of allotment under the provisions of this order may prefer an appeal before the appellate authority within 30 days of the date of receipt of the order. The memorandum. But my lord,
can you just read for the even interim order power is very wide actually.
My lords, should I continue?
Please.
Yes. Clause 2. The memorandum of appeal should be accompanied by a copy of the license of the appellant and a copy of the order against which the appeal has been preferred.
So, page 20. Copy of the order.
My lords.
Yes, next.
My lords, here again. That is my lords. Order Clause 3. Any appeal preferred after expiry of the aforesaid period may be summarily rejected by the appellate authority. 4. No such appeal shall be disposed of unless the aggrieved party has been given a reasonable opportunity of being heard in person. 5. Pending disposal.
So complete. That is what I was referring as complete power.
My lords.
It is a statutory mandate that we have to be heard.
Yeah.
Then kindly read further. Just next one.
5. Pending disposal of appeal, the appellate authority may direct that order of the licensing authority against which the appeal is preferred shall not take effect until the appeal is disposed of. My lords,
so even that is there.
My lords, I get
that. I get.
May I pray be on Friday? I'll just examine because here the ADM is the authority. And if he is the appellate authority and he is the person who is appointed, I will be left with no forum because this appointment is from the ADM authority. Yes. It's the collector.
Then you have to check that doctrine of necessity in PNJ.
My lords, I'll check that vis-a-vis this.
Necessity is exception to or the alterum, nemo judex in res sua.
My lords.
There can be a situation. Usually in official hierarchy, the authority who issues, it is the same person
who listens the appeal.
Justice should not only be done, it should be seen to be done.
Done properly also.
So your point would be that he becomes he adjudicates his own cause.
My lords.
Then another ADM, they can take instruction.
Well, let them take instruction, otherwise also
So if you want,
my lords.
It would be
today you will, I will observe this and adjourn it, or you want that order to be passed? They will obtain instruction.
Let them obtain instruction, my lords, if at all, otherwise.
So I'll record that you will put the ADM.
My lords? No, my lords. Medium,
so that's the problem.
Then my lords, I'll verify. Let it come on Friday.
How I will ask Mr. Lenka?
Let it come on Friday because ADM is the appointing authority.
Then he will say kisi buji pamnandi.
I say buji bag. My case.
Adjournment nole komato kojuni ananto ADM pakura. Apano ADM ko chido kini agar decide hemu. That he will say.
Because once ADM is the appointing authority.
I'll appeal before the.
But nemo judex in res sua. No one should be judge of his own cause.
No, here.
You should kindly look at page 20. File dena thing. Kindly mark page 20.
Yes, sir.
ADM. Bhubaneswar. He sees is the appeal lies to the said authority. Upper top ta dekho. First April. Well, so I'm sorry, letterhead. ସବୁ ଜିନିଷ ଆମେ cost title ଦୁସରେ.
Additional distribution, that is.
She says,
Information.
so that is the most impactful submission. Actually, that is, if we say 19 appeals she will file, then before whom?
Even
Then ADM has passed this order selecting, and it's a case of selection out of 6.
Yes.
may I say out
Sri Lekha, Sri Devi, Jai Mahalakshmi, Chandra Maili, Mamata Mai, Ma Gauri.
the advertisement?
So the ADM has selected
ADM has selected Mamta Mai, my lord.
Mamata Mai.
I'm
You are Sri Devi.
I am no, my lords. I am Om Jai Mahalakshmi.
Jai Mahalakshmi.
And the advertisement
Jai Mahalakshmi.
also
So
floated.
ADM has decided Mamata Mai rejecting Jai Mahalakshmi. Now Jai Mahalakshmi has a grievance. So Jai Mahalakshmi, we have to, I am direct that. Suppose I am direct, or I mean not direct, observe. Statutory, what is there is no need to direction.
Yes.
It was also floated by the ADM, Annex to 1, my lords.
Then
No,
before the
Mr.
collector.
Lenka's response seems that he has got the point also. But today I asked her that if you want, I will say that you will move the authority. From that, she wants to take.
My lords. Actually, I'll be very fair, my lords. Other writs are coming up and they have approached
No,
Mr. Hon'Ble High. In the self, for the self-same.
That's not a precedence.
No, admittedly, my lords. Of course, it doesn't give me precedence. But
Precedence
there is no provision. That is the reason.
Precedence, no, there is a provision. There is a provision. Again, I have to short my eyes to
No, my lords.
26.
Of course, my lords. They
Today at 16.
This is a special guideline which is coming through. That is the reason.
Guideline cannot override the order.
My lords. May I put it to Friday? I'll very cross-check.
Any day you like.
My lords will put because my lords is saying Friday or Monday.
Mr. Lenka, then you have, give your thought to this. The same ADM selecting Mamata Mai and then Jai Mahalakshmi is agreed by selection of Mamata Mai.
Yeah, your lordship, page 20, it is an information supplied under the RTI.
Read
But she has not filed the order appointing the against whom she is challenging before your lordship.
No, read para 4.
That is a recommendation. Man.
Yeah.
It's a recommendation only.
Yeah, or whatever. So maybe because you are raising that issue, it may be the case that Mamata Mai has not been appointed. But when she says an oath, how the court will,
Paragraph 8, I have averred it also that we have approached n number of times as to who is the successful candidate. As if we're not, we had approached.
I'll take instruction.
Answer my learned senior.
I'll take instruction.
My lords.
instruction means you have to, because I hope they will understand the legal proposition.
Yes.
That same author, same authority, not same author, same authority.
One should be the same cause.
He has selected out of the 6, one. One is agreed.
Yes, sir.
Little bit.
You'll have to call it next week.
I'll check that also. May I make a submission? Let them take instruction. Let it come next week. This way or that way it will go, my lord. It will satisfy both parties.
The instruction in this sense, whether, but I think she has been allotted. That instruction is not necessary.
She has been allotted. My condition is that the procedure was not followed.
But unless you say that you will move in appeal, I will not direct them that too.
My lords, then let it.
Because it becomes
I understand, my lords.
theoretical.
My lords, let it.
Correct, but very theoretical.
Admittedly, let it be on Friday.
ଅନ୍ୟ କୋଉଠି ଆପଣ ସିଲେକ୍ସନ କରିବାର ଆପଣ ଏଡିଏମ୍ କୁ ଭଲ ଗୁଡ୍ ବୁକ୍ ରେ ରହିବାକୁ ଚାହୁଁଥିବେ because out of 6
I am
ଅନ୍ୟ ଜାଗାରେ ପାଇବେ. So there are so many practical aspects of a litigation.
I'll satisfy on Friday, my lords, the appeal part of it.
The petitioner is a self-help group. Appearance actually upon changing. Ms. Pratyusha Naidu for the petitioner. Mr. D.N. Lekha. For the OP number 1TO27.
7th also court is there. I think my lord 7th also court is there. If my lord's board is free, my lord's can also. My lord's board is otherwise 7th. I think February court is the most.
7 there is difficulty.
My lord's
this court may not function.
Then my lord 6th is because it's about to be adjusted.
It can be 9th.
No, my lord 6th is good. I'll just verify the point.
9th no difficulty.
My lord.
7th could occupy which. I didn't realize. On the 7th working day achi, what I call it. The petitioner, the petitioner self-help group is before this court challenging selection of the FPS, fair price shop, na?
Yes, sir.
Fair price shop.
Shop.
Fair price shop into bracket FPS for shop. Bracket closed under public distribution system at ward number 49 into bracket Kuleshwari Basti. What if I take it? I'll take some time to dictate this. Take your seat. Yes, yes. No further queries or discrimination. It is submitted that after the petitioner has obtained information from the office of the Additional District Magistrate Bhubaneswar furnished by Additional Civil Supplies Officer. देखिए लिख परियो ना बोल परियो ना पेस्ट होती है Additional Civil Supplies Officer, Bhubaneswar Municipal Corporation. Furnishing information under Right to Information Act -2005. Short for by Subhadra should be Srimati or Sri.
My lord,
Subhadra should be Srimati or Sri.
Srimati, my lord.
And you look at 20. Or see, or Subhadra. Page 20, so subject.
My lords. First,
Maybe I am pronouncing it wrong, Subhadra. Though unusual, but it can be Subhadra.
They wrongly mentioned Sri.
can you see?
Subhadra.
RTA key apply koche aage mu koi perveni. No, my lords, it is Subhadra. Subhadra. She, because she's the, at present, she's the president of that Jai Lakshmi. My lords will see the cost tag.
Subhadra is
Subhadra.
is very unusual.
Subhadra, he's the president of
Then the Rath Yatra rituals has to change. You belong to Puri. What can you? कौन लिख ले? कोट कर देवे श्री सुभद्रा छट्टोई देख CHHATOI ब्रैकेट तापरे कोट कर देले तो इटा into bracket SIC SIC अब कौन italics श्रीमती सुभद्रा छट्टोई bracket closed president of the petitioner self-help group who is also before this yes represented but again you have not mentioned Sri or Srimati, only wife of but that is a very tricky part, you can't be sure.
My lords, nowadays, yes.
I mean,
but my lords, yes, this is
with greatest of respect.
my lords.
No, in fact, in some orders in matrimonial, these mistakes have been
Made.
while dictating the order. He, see, then husband, wife, obviously that follows. Then again, mistake, further problem created. Only self-help group. Stop. The Learned Counsel for the petitioner has adjournment to examine the provisions of the Odisha ODISHL Council. Odisha P.D.S. into bracket control order 2016. Order 4 कहले Mr. Lenka? Order 4 कहले? Order 4.
Order 4.
And order 19.
Order 19.
And order 19. In as much as order 4 provides for FPS subs to be given to self-help groups. Self-help group thoroughly लिखी SHG कर दियो. So SHG and and 19 dot APPEL dot dash into bracket English 1. Any person agreed by an order of the licensing authority refusing to grant tilde dot may prefer an appeal before the appellate authority. Appellate authority define कोटी हेले definition रे अच्छा थी. In case of PDM, it may be different.
Page 52, you'll also see licensing authority, the sub-collector, then the jurisdiction point, but and also ADM, Katak Bhubaneswar. The appellate authority has not been specifically mentioned.
ठीक अच्छी अपन भी बोलते. The Lord DGS will also obtain instruction, like verify who would be the appellate authority in case of the in case the petitioner moves appeal under order 19. Stop. List 9th February.
My lords,
It's on 6th February.
my lords.
List on 6th February 2020. Mr. Lenka, 60 is adequate?
Yes.
Yes.
Oblige, my lords.
Which one?
Sure. Sukurbai.
Yes, please.
Item 9,
May I please, Your Lordship?
Yes. Mr. Kaushik Swai on behalf of
Because they have filed and IA in a disposed of case, the copy, let them solve a copy. In a disposed of case in the year, so they have not solved the IA. They want
IA लिखिए IA WPC 2050 of 2012. Mr. Kaushik Swai for the petitioner ऊपर लिख ले appearance लिख ले. Kaushik Swai for the petitioner, Mr. DN Lenka AGA for the opposite parties 1 and 2. 3-4 blank. IA 408 of 2026 has been filed for recall of order dated 26.09.2023 in WPC number 20505 of 2012. Passed by this bench. Stop. The Lord AGA shall be provided with an extra copy of the petition within 3 days.
Yes, madam.
Within 3 working days. List in the week commencing? 23.
Yes, madam.
23.
But this matter was dismissed for non-prosecution, my lord. Other count.
But the problem is that private parties and 90 days was not there.
Yes, ma'am.
Dismissed for non-prosecution after 13 years. I think it's 11 years. It's a good auspicious also. Auspicious order. Because 11.
My lord, the other counsel who is appearing this matter, my lord.
Check that. What happened to him? You have to check for 11 years what happened to him. 11th year is good for the. Yes.
item 10,
The last listing was, have you marked? The last listing was
13 months.
2013. So after 10 years of last listing, completion of 11 years of filing, the matter has been disposed of. I think that is fair. And also it's on merit. Although I did not look at it, Mr. Lekha, it says that the additional government advocate to the government's made a writ application submits that nothing would survive at present to be adjudicated by this court. That's observation on merit also.
Yes, ma'am. My lord, the fact remains, my lord.
Let us see. You serve a copy. Order copy टा भी नहीं है पर. देखो देखिए इतने paperless से जो देखिए. Yes, next please.
item 10,
Next.
11,
11 में
आपने कॉल करते हैं. 11.
may I please, Your Lordship?
34
Lordship,
and 11.
11, Your Lordship.
34 upon lecture.
I will rectify, Your Lordship.
No, it's fine, it's fine. You might be having two cases, but you should put it in command.
Yes, Your Lordship.
Miss,
Lordship, I will undertake to remove all the defects within 2 days, Your Lordship.
Mrs. Sodangi for the petitioner. The learned counsel for the petitioner seeks how much time?
2 days, Your Lordship.
Submits that the defects spotted by the SR will be removed within 3 working days. Upon removal of the defects, the registry shall verify and proceed for listing of the matter under the heading fresh admission. List in the week commencing? Please do it to move for this.
Obliged, Your Lordship.
Yes, next.
Well,
In this case, the SLP is pending. It has been heard on 10/12/2025 and
order deଇ ପାରିବେ ଆପଣ ଯୋଉଟା downloaded from the official website of the Supreme Court ସେ order ଟାକୁ ଦେଖେଇଲେ ସେଟା you can get the date and mention it. Anyway, Mr. Prem Kumar Mahanti for the appellant. MS Mahanti.
Sole respondent.
Sorry, S Mahanti.
PS Mahanti.
PS Mahanti, yes. PS Mahanti for the respondent. It is submitted by the learned counsel for the learned ASC for the appellant that the SLP arising out of?
SLP is pending. SLP number 215/216 2023.
Whether connected, how connected? Anyway, the connected SLP is pending before the Honorable Apex Court. Next date of listing is?
It was heard on 10/12. That I am not in.
The learned ASC shall provide the details of the SLP to the learned counsel for the respondent. Adjourned sine die?
Yes.
The matter is adjourned sine die, awaiting result of the SLP. Liberty to mention.
No.
If you check it, since
Both the
without looking at order, I do not know also.
Madam.
Okay. Yes.
13,
Yes, next please.
No. I'm for the opposite patrons.
Can you please wait or will adjourn it to some other day? Other day. 13 appellant petitioner non-lekhibe. You are Mr. Patnaik.
Yes, ma'am.
Mr. D.N. Patnaik for the Devendra Patnaik for the opposite party. Non-appeals for the petitioner when the matter is called. To grant further opportunity, list in. Karantu jaldi.
we commencing do it.
We commencing do it in.
Obliged.
Yes, next please.
14,
Notice on admission and limitation issued twice, but it was even if through process of court, which was returned addressee not located. So
We have to you take time and try to discover the.
My lord, I think in family court execution case is continuing. So
Where? District Judge Sundargarh?
My lord.
Look at, just use the paperless.
My lord.
You have a cause list or look at the.
My lord. It was also
District Judge
addressee
says-
cannot be located.
So that precludes this course. Now you laugh at me if I say that the district judge will serve.
My lord.
Can't be located is the finding.
My lord,
I think you try to ascertain whether she is receiving the money. If at all any execution is there or any payment is there, there is a possibility she will come to receive that.
my lord.
Or through that method you can locate her present location.
My lord, distress warrant has been issued. So I have
Can be done.
I pray only distress warrant.
It has to be that way. If you read the jurisprudence on this, courts have to enforce this.
Maybe taken up next week.
I'm adjourning it by 1 week, 1 month, 2 weeks. That much I can help you.
My lord.
The proceeding, further proceeding in that. In the meanwhile, you take steps to.
My lord.
Hala?
My lord.
Mr. Srinivas Satpathy for the petitioner, opposite party blank. Office note pursuant to the notices issued earlier, comma, twice in the present matter, comma. Notices were issued by RP with AD as well as through the court process. The effort to serve notice by both the methods have not yielded result. Have not yielded. Has not yielded any result. As the notices have been returned unserved. With the following notice as indicated in the office note. देखिए लिख देवे एड्रेस from the stop colon देख कर दियंतु from the postal by postal endorsement addressee can't located comma hence return to sender into bracket C from the office of the district judge quote addressee cannot be located para. The learned counsel for the petitioner submits that he has no instruction as to whether if any amount is being received by the opposite party in any proceeding towards maintenance. Stop. However, he will obtain instructions regarding the same. He submits that the petitioner shall also make an effort to find out the present correct address of the opposite party. आइएटा कोड आइएटा पर
मेलर आइए 14
14 14 amendment कौन सबू जाक अमेंडमेंट लिखी पकड़ टाइप कला बड़े देखले
माइलर
आइए 3 रे कौन लिखियो
सॉरी
Upon why you are not depositing that amount here? Up there. How much is due?
1,53,000.
How much you will deposit before the Lord trial court?
No, in execution from execution notice, I came to know.
How much you will deposit?
I can deposit 50,000, my lord.
Deposit 1 lakh.
Maybe 70,
Because
75.
after Justice versus Neha, I will be passing an illegal order. This is exactly the mandate of Justice versus Neha that maintenance has to be dealt by like a money decree.
My lord,
75 lakhs deposit केबे करियो
75,000 within the month.
और टोटल केते ड्यू हेलानी खोज
1,53,000 execution to 1,53,000.
एई साइड 24 2 वर्ष पळेलानी.
My lord, 9,000 मु ट्यूशन ये तार इनकम अनएम्प्लॉयड पिला और 9,000 कर देचंती एक्सपर्ट रे हिचे माने ऑल्दो नॉट एक्सपर्ट किछ वकील हमर लेचेस जो
नॉट एक्सपर्ट
नहीं एक्सपर्ट नुहे. My lord, kindly see the order sheet. टोटल जे वकीलंकर अपीयरेंस टाको भी जो ये टाको बकला मास
ट्यूशन ने हिसाब करी करछन
3,000 टका लगा 4,000 पर 9,000 कर देछन कोर्ट माने गोटे ग्रेजुएशन पिला केते ट्यूशन रे पाइबो
सेटा मते पचले आई हैव अ नॉलेज सो डोंट आस्क मी
अगेन
स्काई इज द लिमिट
मैटर
ट्यूशन जे भलरे करि परियो बहुत पैसा पाए
75,000 दबो
1 लाख आपनकर प्रॉब्लम होची आपनकर काहेकि से 1 लाख एटलीस्ट
अगे
ଆପଣଙ୍କର 28,23
ଆଜ୍ଞା
So
1 lakh 1 lakh
so already ଆପଣଙ୍କର ପଳେଇଲାଣି still it is very less.
ଆଜ୍ଞା
କଣ ଲେଖିଲେ? IA number 3 of 2025. It is submitted by the Learned Counsel for the petitioner that due to inadvertence, typographical error has crept into the cost title, wherein it is stated that the application has been filed for amendment. Stop. He seeks leave to correct the cost title. To indicate that the application is made for made seeking stay of further proceeding. In C criminal proceeding number 126 of 2022. Under section 128 of CRPC, pending before the Learned Judge Family Court Rourkela. Stop. Apparently the judgment which is sought for ତାପରେ ଲେଖିବେ amendment ଲେଖିଲି 6 leave ତାପରେ ଲେଖନ୍ତୁ ଦେଶଟା କାଟି ଦିଅନ୍ତୁ. The prayer is allowed, leave granted. The Learned Counsel for the petitioner shall carry out the necessary corrections in the cost title of IA number 3 of 2025, which shall bear his endorsement to be countersigned by the court master. The IA has been filed seeking stay of further proceeding in so and so charge. The judgment included in the RPFM is 28/8/2023, passed in criminal proceeding number 42 of 2022. So it is 4 years.
criminal proceeding number 126 of 2023 execution 128
judgment for execution court judgment on by the Learned Judge Family Court Rourkela. Stop. By the said proceeding, the petition filed under 125 of CRPC by the wife in the marriage seeking maintenance. Stop. Thereafter, she has filed a petition under section 126 of 2022. Right. Yes, she has filed application under section 126 of CRPC. Or 125(3). She has filed a petition under section 125(3) of the CRPC. That is criminal proceeding number 126 of 2022 for realization of the maintenance amount. The petitioner has adjournment to deposit rupees 1 lakh as undertaken before this court. Memo
within a month.
Sorry?
Within a month, my lord. 30 days, my lord.
4 ବର୍ଷ ପରେ ଗୋଟେ ମାସ କେମିତି ନେବେ? You have made it really luxurious litigation. କେବେ ଡେଟ୍ କେବେ କହୁଛନ୍ତି ଦେବେ ତାରିଖ?
ମୁଁ କହୁଛି
ସ୍ପେସିଫିକ ଡେଟ୍ କରିଦିଅନ୍ତୁ, କନଫ୍ୟୁଜନ ହବ।
my lord, by February 10 ମାର୍ଚ୍ଚ ଭିତରେ 10th ମାର୍ଚ୍ଚ ଭିତରେ।
ଆପଣଙ୍କର 1 month ହଉଛି
sorry by February 2 ଭିତରେ ଦେଇଦେବୁ। ମାର୍ଚ୍ଚ 2
that he shall make କଣ ଲେଖିଲେ? By the petitioner before this court, in terms of the memo filed by the learned counsel for the petitioner. Memo of date. So, as undertaken, the said amount shall be deposited by 6/3/2026. Stop. In the interim, no, it is further directed the learned judge family court shall await deposit of ₹1 lakh by the judgment debtor dash petitioner dash husband in the marriage. So, upon deposit of ₹1 lakh on or before 6 March 2026, the further proceeding in criminal proceeding number 126 of 2022 under section 128 of CRPC. The 128, 125, 128 shall be adjourned, subject to further orders to be passed by this court. List in the week commencing 16 March 2026. The petitioner shall file the proof of deposit of ₹1 lakh before the learned judge, before the court of learned judge family court, Raukela, supported by affidavit. Yes. Yes, next please.
Item 15.
Yes, please.
In the present case, I am for the petitioner.
You Mr. Mohanty. Mr. S.K. Mohanty for the petitioner.
In the present case, there is condonation of delay. The miscase is pending for condonation of delay. The matter relates to maintenance. I thought daughter against the father. The opposite father is a bank employee, retired bank employee. I am getting, I thought the admission is getting 36,000.
Has been rejected.
2,000 days I have filed for enhancement.
You are seeking enhancement. But she is major.
Major.
Unmarried.
Unmarried.
RPFM এটা আইএটা হচ্ছে 170 আইএ 170 of 2025 along with RPFM number 119 of 2025. The petitioner unmarried daughter, who the daughter of the opposite party father, is before this court seeking enhancement of the amount of maintenance granted by the learned judge, family court, Jajpur, in CP number 133 of 2023. Stop. The said CP was filed under the provisions of section 2(20)(3) of Hindu Adoption and Maintenance Act, seeking maintenance and marriage expenses. Why you are not getting married?
For insufficient funds, right? Corporate account.
Should get married, and then you can actually state the amount spent as expenses. Because you are seeking a 10 lakhs, which is a very reasonable amount, of course. 10 lakhs as marriage expenses is a very reasonable account. It's only maintenance at ₹7,000 per month and ₹10 lakhs as marriage expenses, as it is stated that her marriage has been fixed. The learned judge family court, Jajpur, has allowed the petition granting granting rupees 2,000 per month as maintenance from the date of application, that is 21/4/2023, and rupees 5 lakhs towards marriage expenses. Issue notice in the IA as well as the RPF along with this order.
Opposite party have already acted.
Notice issue which in a set up
Notice by actors.
Pursuant to the notices issued by order dated 1/8/2025, the opposite party has entered appearance to this. Appearance to Learned Council. None is present today on behalf of the opposite party. List in the week commencing.
Nothing.
Make the lamba korotuni. Orders may have seen. আমি আজকে কোড আর আছে ফেব্রুয়ারি আচ্ছা ন আচ্ছা হ্যাঁ ওটা উল্টো পাল্টা আছে সেপটে মার্চ 9/3 ଆପଣ in the week commencing 23/2/2026 the registry shall intimate the next date of listing to the Learned Council for the opposite party. ଆପଣ ପାଉଛନ୍ତି ନା ପାଉନାହାନ୍ତି? Application file କରିନାହାନ୍ତି? It is clarified that the petitioner is entitled to receive the amount of maintenance as well as the marriage expenses as directed without prejudice to her rights and contentions in the present application. You should have made that move on the first date. When you move this application, you should have taken that, mentioned that. So you can file for execution. What can be done by the appellate court?
Because I'm challenging the order for which I am.
Whenever you challenge that, if somebody is finding it difficult to maintain herself, he herself is challenging for an enhancement, then you have to seek that leave from the court that I will receive it, but allow me to receive and I will challenge the quantum. That's a different thing. Yes. I hope you understand what I'm saying.
Right.
Yes. Next, please.
17.
So you are for the opposite party?
Yes, file.
Can you wait or pass orders? Pass over kariba?
Pass over karo.
ठीक है.
18.
May I please, Your Lordship?
So what's your name?
Lordship, Bhakti Prasad Samal.
So Bhakti Prasad Samal for the petitioner. So Lakshmi has received instead of Nalini.
Lordship, we have filed one matta and we have represented the same address. In that case,
So you follow English, sir. You speak very good English. So what is the question to you?
Lordship, আমি সেই same address রে পঠিয়েছিল।
In English, sir, you are speaking very well. What was the if you are not attentive to the court's query, then you please inform me. Otherwise, I am at loss. What did I tell you regarding service?
Lordship, I don't know who is Lakshmi, but
So then how the court will know? If a notice issued to Nalini is delivered to Lakshmi by the postal authority and a return is given and office notice put up, you must understand what you are saying. This is not, you can't be casual even in a orders matter. You are saying same address, in same address, Nalini and Lakshmi are staying together. Would it be sufficient? You must understand what you are arguing. Suppose now what order I can pass? Though Lakshmi has received the notice, but it is since it is in the same address, it will be treated as sufficient on Nalini.
Lordship,
Can it be your submission or my order?
no, Your Lordship.
Then you have to be careful. Yes, what do you say? or I'll wait for you to submit. And
Well,
also put some idea.
I will take fresh steps.
And other aspect is that at times the person who is receiving, they are not that particular or they are not that educated to understand what they are doing. This is our society. You can't say that they are literate, they understand what they are looking at. Can be deliberate also. Can be deliberate. We do not know, but
Yes, Your Lordship.
we can't attribute motive to that. How many times your letters are received by you or somebody else in your house?
I have received always.
But I am yet to receive all my books and all that as a lawyer. I was not available at my home to receive books. So that's a benefit extended by the postal department to a particular everyone, AIR, SEC, everything was coming by registered post. Pursuant to the notices issued by this court by order dated 2/12/2025, notices were issued. Office note put up regarding regarding the sufficiency of notice. Office note put up by the registry indicates neither ready nor unserved notice in admission matter received from the sole respondent. Order the postal office note dated 28/1/26. Today, when the matter is taken up, none has appeared on behalf of the sole respondent. You will wait for take some time. She may appear. Then you take steps.
Yes, Your Lordship.
Though it is not apparent whether the opposite party has received notice. It is submitted by the Lord Counsel for the petitioner that the notices were taken in the same address given in the
Matta number
PA, which is pending before this court. The connected MATN number
130 of 2024, Your Lordship.
फाइल लिखिए हाତରେ लिखिବେନି ଆପଣ ଫାଇଲ ଏଟା ଦରକାର 130 of
2024
para you will appear.
Let this come matter.
That is what experience.
I'll file booklet.
Non-appointed particular asiale Mr. Mohanty.
Today I'll file booklet.
Today, when the matter is taken up, Mr. S. Mohanty, Lord at Counsel, submits that he has instructions to appear and shall file Wakalatnama within 3 working days. Upon filing of the Wakalatnama, the name of the Learned Counsel, Mr. Mohanty and Associates and Learned Associates shall be indicated in the cause list as well as the case brief. List in the week commencing? North in Korea. Yes. So the discussion has some basis. I could not have predicted, but I mean some rational thought. So your argument was partly wrong. You have to be careful.
Isn't.
They never intended to evade. Yes.
19.
देखी दियंतु आपण तो पास ओवर करछन काकु कर दियंतु आपण ठीक अछि
20.
May I please your lordship?
Sufficient, but hopefully someone will appear.
All are government parties. One is the governing body.
Governing body of which college is a government?
That is
Anandapur College.
Anandapur College, my lord.
No, they are not appearing. Are you appearing for
In the-
principal?
I'll have to check up.
Eh?
Is it in
Lebe,
the
Lebe.
read
They can engage you. ଆପଣ ସେମ୍ ଏପ୍ରିଲରେ କାହାକୁ ପାର୍ଟି କରି କାହାକୁ ନୋଟିସ୍ ନେଇଥିଲେ?
ସମସ୍ତଙ୍କୁ, all the three opposite parties were there in the writ petition. Notice has gone, the letter has gone to principal secretary government higher education department and director of higher education. Only two parties.
Correct, sir. We are discussing something else.
Well,
Did you hear your Rodit colleague? He says that you can appear.
one and two.
Okay. So what do you say? You'll file response to the same appeal?
And file response.
Of course,
Time be given.
Three has to be.
Three, I am not appearing, my lord. I think it's a private college, man.
Anandapur is a category 1 fully aided college. But yes, you are right. That is my understanding that you cannot appear, but they can engage you so that the matter can proceed. It is. I'm not directing. I don't want to pass an order. I understand what you are saying, but they can engage if it is a or they can anyone. You take ask the director to ask them.
I'll take instruction.
Yes.
In the writ also, my lord,
Mr. P.C. Chinchani for the petitioner. Same appeal only. Mr. Ikke Mahanti, Prem Kumar Mahanti for OP number 1 and 2. The Learned Council, the Learned Additional Standing Council cannot be AC. Additional Standing Council submits 6 for the time to obtain instructions from the OP number 1 and 2 in response to the same appeal. The Learned AC shall also obtain instructions from the Director Higher Education as to why the principal, Anandapur College at Anandapur, District Keonjhar, is not responding after the notice issued by this court is not sufficient. The football line likhibe. Today, none appears for the OP number 3 when the matter is called. Unless Mr. Mahanti, there is no conflict of, possibly there is no conflict of interest, then you can also appear.
I'll take instruction.
They have to file.
Unless I take instruction, how can I?
Yes. You ask them that why they are not appearing.
Yes.
And we have to wait for that sufficiency of notice. Could it be? List in the week commencing?
notice has become sufficient, man.
That I have observed. That is the reason I am asking. Otherwise, I could not.
Nothing.
The week commencing, nothing. Yes, please, next.
21.
May I please, Lordship?
This is Babita Patnaik for the petitioner. So, Maharana.
Man, I am Dilip Kumar Sahu on the respondent.
Sahoo. Dilip Kumar Sahu for the opposite party. Objection file any?
नहीं करिनो
अच्छा
570 दिन
order ଥିଲା
ଆଜ୍ଞା
can you please refer to the order
delay of the content.
coordinate bench କୋଉଥିରେ order କରିଥିଲେ ସେଟା ମୁଁ ପଚାରୁଛି so that I'll go faster.
Honorable court orders that the file and further file.
Counsel for the opposite parties refers to the order dated 13.01.2026 to submit. He may be granted further time to file objection to the IE.
This is the 4 times minded.
He will take 3 times. He will take 4. Mr. Mahanti takes usually 8-9 times. So there is a competition in taking time.
Minded my son.
And hopefully, I instead of taking time, I will try to go through the list and hear all of you.
My humble submission. I number 1.
Let us not do it that way. Let us. The hearing has to be in order. Without continuing delay, I start hearing. Can I conclude anything?
Proceedings of the educations may kindly be.
No. Execution, the custody. You are the husband.
No, I am for baby child. I am for the petitioner.
Baby child is Nirod Kumar.
Nirod Maharana is the grandfather and grandmother.
Custody is with whom?
The husband.
No, my lord.
Natural guardian.
No, my lord. The case is that
Nirod Kumar
is my
father-in-law.
Father-in-law.
Yes.
And child in the father-in-law house, my lord.
Grandparents. Actually, my lord,
say next date of hearing କେବେ ଅଛି?
21/2/25 ରେ ଅଛି ନେକ୍ସଟ ହିୟରିଂ ଏକ୍ଜିକ୍ୟୁସନ ଟା।
education ର ଅଛି। ମୁଁ
ସେଟା
ନେଇକି
ସେଟା ଆଉ ଗୋଟେ ଦିନକୁ ରହୁ ହେଲା ଆପଣ
ହଁ।
ଠିକ ଅଛି ଯଦି submit
As per
ଆଇଟା କେତେ ଫାଇଲ କରିଛନ୍ତି
ଏଇଟା
ଆପଣ ଏଥିରେ
15/25
this is not the approach you should make.
This is the very
National guardian you will deprive.
ମାନେ ଆକ୍ଚୁଆଲି ହନେବଲ ସୁପ୍ରିମକୋର୍ଟ ଗ୍ରାଣ୍ଟେଡ ଇନ୍ 7 ଫେବୃଆରୀ 2025 ରେ ବିବେକ କୁମାର ଚତୁର୍ବେଦୀ versus another versus state of UP and others ରେ allow the natural guardian, my lord.
No,
So that's not the only case. Supreme Court has also denied.
this is the
Natural guardian welfare of the child,
Take that West Bengal case.
my lord.
This High Court has referred, division bench has referred to that West Bengal case. In certain cases, the custody is denied to the father. And in certain cases, it is granted to the father.
now the case isn't
You have to check up.
that case is in
Because the submission that said is that he is alleged of committing the crime.
yes.
Allegation is not sufficient, even if in case of allegations of commission of crime,
It is
he will
pending
be
in the
granted.
session court also. That's true.
Because there is presumption of innocence. You have to examine the decision right on the point. General discussion doesn't help here. Because both ways the case law has developed, evolved.
My lord.
The jurisprudence has evolved.
Actually, this is the protection of the baby child. Actually, baby child now is growing.
ଆଜ୍ଞା ସେ 70 ବର୍ଷର ପ୍ଲସ୍ ଏବେ ସେ ଯୋଉ ମାନେ ଗ୍ରାଣ୍ଡ
Reading last time you are not making what citation I gave you to read.
I'll give you.
What is the, I'm asking you the name I will give. Yesterday I told and then I again asked you. You did not recollect. You did not vote also. You should assist me or I will assist you.
Yes, I'll give it.
What is the decision?
Decision of
Supreme
Court judgment. Yes, there is a
Smriti Madan Consagra versus Ferry Consagra. He is citing our and in your favor that West Bengal decision is there, Supreme Court decision. Some Chakraborty
next time.
and Odisha High Court has dealt with those decisions, division bench. Justice B.N. Ratha and Justice M.S. Sahoo. They have dealt with custody.
My lord, also ଯୋଉ ପୂର୍ଣ୍ଣ ୱାଦୁଆ and ଅଜୟ ୱାଦୁଆ 25 ତାଙ୍କର
ଛୁଆର ବୟସ କେତେ?
ଆମର 13 ବର୍ଷ ଆଜ୍ଞା ହେଇଗଲାଣି।
ନାଇଁ ତ 4 ବର୍ଷରେ ଏମାନେ ନେଇଥିଲେ
ବର୍ତ୍ତମାନ କେତେ କଣ
11 years
ତାପରେ ଟ୍ରାଏଲ କୋର୍ଟ ଷ୍ଟେ କରିଦେଲା ବଡ ହବନି ଛୁଆ 4 ବର୍ଷରେ
11 years na 11 years plus. Now she is reading in standard.
You mean to say that the father doesn't know what is the age of his child?
No, actually no, the father
In submissions, madam. Make a compact submission. You are leaving all loose ends in your submission. He will ask you, madam, after he grows up, he will seek his identity. You will seek his identity, and that is the exact case. What you should have examined that case.
My lord.
Odisha High Court has dealt with that. That when there is allegation of this,
in the order
it's submitted by the Lord Counsel for the petitioner that the opposite party has filed execution. Would I be judging that? Who I stay baguchandi?
I number 1. Proceedings of the
I number 20 of 20. I am 20 of 2020. The IE has been filed for stay of proceedings.
Yes.
Nada kon proceeding nada kon.
CP number 15th of 2025 filed by the opposite by Dilip Kumar Ochal.
My lord, IDA 201/26 होची जो स्टेप एजुकेशन my lord. स्टे अप जो
केस नंबर टे कहले भलो होतन.
केस नंबर
CP number 15th of 2025 proceedings.
Education case
Education proceedings.
Education case number 15/25 my lord.
That is execution case number 15 of
2025.
2025. Arising out of
CP
number 22 of 2023. Dispensed of by order dated 23/12/2023.
My lord.
Para. hard ordered counsel for the parties at length. It is in the interim, it is directed that on the next date of listing before the Lord Judge Family Court, Venkana, that is 21/2.
21/2
21/2/26. The matter shall be adjourned by 6 weeks to a date suitable for to a convenient date convenient to the allotted court. List on कुछ लिए 9/3 को listing the week commencing 16/3. Yes, Madam Patnaik.
Yes, my lord.
Mr. Sahoo.
Melody committee resort.
None.
February ମାସରୁ
अरे ଆପଣ stay नहीं ଗଲେଣି ସିଏ ବର୍ତ୍ତମାନ କହିବା କଥା ଯେ ଜଲ୍ଦି ରଖନ୍ତୁ କଣ ଆପଣ ଏମିତି flip
ନାଇଁ ନାଇଁ
flop
ଆଜ୍ଞା
କଣ ସେମିତି ଟିକେ କୋଅର୍ଡିନେଟ୍ କରୁନାହାନ୍ତି ସେ କଷ୍ଟଡିରେ ବି ଭିଜିଟେସନ after you have obtained a stay order you should
This is the life of the baby child.
अरे life of the baby child एमती करा जाएନି I cannot record that I can't pass illegal orders like saying that life of the baby child custody granted to grandparents. What is the decision I have informed you right now? Two decisions.
Yes, I have to decide.
So those things you have to remember to protect the life of a baby child
Right.
and life of law also. Because law cannot be, threatened or stifled. List in the week commencing 9/3/26.
Oh, bless me.
Item 22.
Bless no one.
Nanti ki apna notice. Oh Korea. After recess mat dakho to audhar. Apna upuru bi gude pass over kari pagale. All the matters where if you want adjournments, inform him, he will give you the adjournments. Somehow there is a little bit thin attendance. So let us take the after notice matters after recess. Take a break, no difficult. Wherever both parties are there, it is better after notice matter. And if you are taking adjournment in the absence of the other side, please inform.
Other party is to file counter matter, not
Whatever, sir.
It is why I paid for it.
Let us try to hear also. Completely.
It is for counter matter, but it will next week I paid for it.
ठीक है चलो but next week सेम रखो the list gets cramped. Date कर देवे चलो Mr. Sahoo, your matter.
Right up 38 lordships. Now they are the 65 years and 58 years of age, my lord. So let them at least mediation last 30 times.
Sir, maintenance account mediation नहीं कर
30 times
maintenance
let the chance take a chance.
If they are not responding to court, nothing will happen.
Maintenance.
No, actually, what order can mediator is unable to arrive at anything.
In lower court is.
देखो कौन करिया तो अपन वेट करो तो I will not pass any maintenance sorry mediation order in maintenance.
Times court not the mediation.
I mean, the mediation is now overburdened and maintenance what mediation they will make after 6 months or 3 months they are giving report that failure because he's unwilling to pay. It's a matter of execution. Like say section 9 Hindu Marriage Act mediation difficult but still there is a possibility that restoration can be done. Corresponding to the date okay, no difficult.
Item 31.
Mr. Sahoo might have some other, so you have to accommodate it. Usually he accommodates you.
Your Lordship, for item 25, I am praying for an adjournment.
Please, after notice matters, inform the other side. Take that responsibility. Don't put that border on me that I will inform or they will mention.
Item 31, my.
Mr. Pravat, जोटा मागुचंती आपण डेट करि देबे but try to get a date from the other side नहले लिखि देबे डेट कर देबे.
Item 31, my. Item 31.
You want any matter you want a date, please take it.
No, my senior is there. Item 40 for the interest of the both the party will pray for the sent to mediation.
That I have to take up that matter. I'm not sure. I'll be coming back. ଆପଣ 500 ଓଭର କରିଛନ୍ତି ପରା?
Recording in
Monday
progress.
21 ଟା କଣ? 21 ତ already hearing ହେଇଛି। ଆପଣ କୋଉ matter? ଆପଣ ଅନ୍ୟ କୋଉ matter?
41, 41.
First one date କରିଦିଅ। Sorry,
Yes.
ମତେ 21 ଶୋଇଲା, 21 ତ hearing ହେଲା, କଣ confuse ହେଇଗଲା।
We come also page 3.
Yes.
Item next week any date lordships.
କୋଉଟା ଗଲେ?
Item 38.
ସେଠି ଟିକେ ପଢୁ। Let us go see one by one. ଯଦି ଆପଣ both of you can agree, ask Mr. Das, but let us call the list.
Passover item 10.
Non-appeals for the petitioner, though the matter is called twice over. Once when it is, and again after resumption of the proceeding, post recess. Stuff. Grant further opportunity list in the week commencing.
Not.
Not in 26.
Passover item 17.
17 in this matter, my lord, I have filed a petition for condonation of delay. My friend has appeared and
But I
Not
have
filed
filed the opposite party, my lord. But I have received the notice on delay ground, my lord. But I will file my objection, my lord.
You I mean, both you have not received.
Yes, both
The
received.
notices were issued only in the IA, you are saying.
Yes, my lord, only in the IA. Because, my lord, there is a 280 days delay.
218.
218.
Okay.
My lord, I will file my objection.
Mr. S.S. Rao, senior advocate, along with Mr. B.K. Mahanti for the petitioner, Mr. Kuldeep Mahanti for the opposite party. Learned counsel for the opposite party has how much time you are saying? 2 weeks.
One week.
Has 1 week time to file response to the IA seeking condonation of delay. You like to have a copy of the appeal memo also on a petition?
Yes, man.
He shall also be provided with a copy of the petition by the learned instructing counsel within 3 working days. तब about 10 days कर दो, 2 weeks कर दो. Copy देवे 3 दिन, तब 2 weeks कर दो. Yeah, before that 2 weeks. 2 weeks. तापरे copy shall be served within 3 days, 3 working days. List in the week commencing 23/2/2024. Same order as in call twice over. है ना?
Number
Nineteen बुझले? Call twice over. Not in 11.
Not.
19 डाकिले. 19.
Item 22.
Serial election.
Okay.
Posting कर दियो तो. Non appears for the 22 लिखो तो non appears for the parties. When the matter is called. List in the week commencing 23/26. Yes.
23.
Same order.
24.
My lord, there will be notings may kindly be sent. With counter and rejoinder, etc. The additional affidavit by the petitioner not filed. That is not required, so that is not. Therefore, my lord, consolidated writ petition filed, but pages are not matched with the originals. That I am to get it ready, my lord. I will correct
You
it.
take the liberty to refile also.
No,
That's what happens because the correction and
That's a
additional pages because
consolidated pages.
I understand.
I'll see that is correct. Yes. Then
notice not.
That is made sufficient. My learned friend appeals for that. And he has also filed it.
You have appealed.
I am appealing for OP number 4 and 5.
Yes.
Today I am filing additional counter.
You file it in the registry.
Yes.
They have served me a copy.
I have already served.
Then
I may be required to file counter because prior to amendment we have filed.
I didn't have attention. Please.
Prior to amendment we have filed counter. We may be required to file fresh counter.
No, you just allow the petitioner to make the final copy of the amendment.
Yes.
There is some discrepancy in pages and.
Yes, Mr.
what I pray, my
If you
lord.
pray, if you can refile also by typing it out again by incorporating all the annexer and index. No difficulty. I think that would be better approach. Because like you insert 2A, 3A, those pages have to be inserted. Paragraph, you have to insert 5A, 6A, then it overshoots another page. Annexer obviously has a difficulty again in the index.
As your lordship directs that.
No, you take you have the liberty. No difficulty. Why I am saying because Mr. Government Counsel and Mr. Swai both should know that.
This is my problem.
Though the defect is that pages do not match. But if the petitioner chooses to file it again, so no difficulty.
Yes.
What I pray, my lord, because this is an old matter.
Yes.
Therefore, my lord, will fix up an early date. In between, we will comply with it.
Oh. Mr. J.K. Ratha, Senior Advocate, instructed by Mr. Ratha, Durgesh Narayan Ratha for the petitioner. Mr. P.K. Sahoo, Additional Standing Counsel. For OP number 1, 2, and 3. One, 2, and 3. Again, 4 newly added. Amended each.
4 was there.
amended
4 was there. 5 was newly added.
Acha.
5 is only added.
For 5 I am filing Vakalat now.
4 was there.
4 was earlier there.
You file it in the register, no difficulty.
Yes.
But my cost title doesn't show.
Yes.
Mr. Ratha carried out in hand.
My lord.
The addition was carried out by hand or type copy is there?
No, type copy was there. That was allowed also, my lord.
Sure.
The amendment was allowed. Consolidated petition is filed according to that. However, there is an objection.
Yes.
It doesn't number page measure.
By earlier order, judicial order, it was allowed.
Better one.
5 was newly added.
Notice 5 was newly added and they filed a counter.
Yes.
Oral prayer rahitla.
Mr. Sahoo it.
It is submitted by the senior advocate for the petitioner that pursuant to the order date number 21 dated 7/5/2025, the amended application has been filed. Stop. Office note put up by the registry after SR indicates that the pages are not matching with the original writ petition. Red flag W. No, not W. Is not matching for that. Stop kar de. Not matching with the original writ petition. Stop. So, para it is submitted by the senior advocate that steps shall be taken by the learned instructing counsel to remove the defects. Stop. As prayed for, the petitioner shall have liberty to refile the writ petition, consolidated writ petition with amendments.
Yes, sir. Consolidated petition.
And necessary changes in the and accordingly the necessary changes in the pagination and annexer as would be. Stop. Mr. K.K. Swai, learned advocate, submits that he has instructions to appear on behalf of. He had appeared.
I had appeared on behalf of OP number 4.
And
now I will appear on behalf of
the OP number 5. Newly added OP number 5.
Yes.
Okalatnama on behalf executed by the OP number 5 shall be filed in the registry today.
Yes.
The Okalatnama shall be accepted. Scanned copy be updated name of Mr. K.K. Swine or an advocate and associates shall be reflected in the cause list as well as the case brief. From the next listing onwards, appearing on behalf of the number 5. It's a for the counter 4.5.
The counter they have filed.
Four.
Earlier, I filed
4 and 5.
for OP number 4. Now for OP number 4 and 5, I am filing additional count.
Copy of the, it is submitted by Mr. Swine or at counsel. That counter affidavit on behalf of OP number 4 was filed earlier.
Yes.
And additional counter affidavit dated
2 days. 18/1.
Dated 18 18/8/2026 will be filed in the court.
Yes.
Has been filed in the registry today.
Yes.
Copy of the
Copy already served.
counter as well as the additional counter has been served on the London Instructing Council.
Already served.
Has been served.
Yes, sir.
Mr. Sahoo.
Yes, yes.
Sir,
My lord, yes, I have
copy has
received
also
today.
been served on the London ASC.
Today.
So the counters, the counter, additional counter shall be taken on record, scanned copy be updated. Stop. Tapar likhibe, the London ASC submits that he shall obtain instruction in response to the amended writ petition. So you are responding to amended or the original?
Amended. They responded to amended.
Additional,
I am responding to the amendment.
And if you advise, I'll file additional counter in response to the amended.
You'll also say counter. Earlier, both the hit. Objection to file. Objection affidavit to file.
Counter additional counter in response to the counter oblique additional counter. Take up both additional counters. It should capture both. The counter in response to the writ petition. Within
2 weeks.
Within 2 weeks.
Sir.
I'll try, but
13 matter. I'm going to die.
2 weeks is reasonable.
List in the week commencing 23 week.
Yes.
4 and 5. Last the registry shall update the case brief as well as the scanned copy. Yes. Indicating the correct cause title as well as all the pages and annexes of the writ application.
Item 26.
So this is the same as 22. So 22 yes, please.
Page 2. There is
32. May. Mr. Sundaranjan Das for the petitioner. The Archuman Sethi for additional standing counsel for the opposite party. Is it right for hearing? Pleadings complete?
My lord.
Of Das?
My lord.
Yes.
My lord, it's a matter relating to rehabilitation assistance scheme.
Yes.
Writ appeal order passed by the division bench of this honorable court was upheld by the Supreme Court. This is the judgment.
Luha.
Luha.
Then
thereafter, this they called for him to file a fresh application. Accordingly filed. Thereafter, there is no response.
The amended regime is 4/4/2025.
My lord.
The writ petition is 2022.
There was a direction in this.
Look at the judgment of the Supreme Court. Date. Only date I require.
My lord, para 12 it has been clarified.
Para 12 is never a date, sir. Date comes with a day, month and date. Year.
May 2, 2025.
So how a 2022 application will deal with that?
They have clarified that previously those who have applied.
Sir, I have also little understood. You have understood. But my question is not that nuanced also. It is a simple question.
My lord.
You are saying that he has applied, but the application is 22. The amendment is 4/4/2020.
Yeah, he had applied in 2019.
Correct, sir. So
Yes.
after 4, we will read that of Jita Luha, read the operative portion.
My lord.
And read our, we have disposed of several applications.
Yes, my lord. My lord also has been upheld.
No. Kindly look at that operative portion of Jita Luha.
My lord. Para 12, my lord. I am providing a copy.
No, you can read, sir.
After hearing the learned advocate general.
Give it to Mr. Sethi so that he will just read along with you.
After hearing the learned advocate general and learned advocate appearing for respondent and bestowing our consideration in a view, direction issued in the order impugned find force from the amended rules notified on 4/4/2025. Referable. Therefore, we are inclined to maintain the order of the High Court and to dispose of all these appeals with the following direction.
Please.
Respondents are at liberty to submit an application if not already submitted within a period of 2 weeks to the jurisdictional authority along with requisite document as specified in the notification dated 4/4/2025. In the cases where application has already been submitted and any additional document are required to be submitted, same be furnished to the authority in reference to the pending application or in reference to the demand made by the authority, if any, within the same period of 12 weeks. C. Third, on receiving the application as mentioned above, appropriate authorities shall examine the case of individual respondent in terms of the 2025 amended rules and pass appropriate order. It is needless to say that the application so filed shall not be rejected on technical grounds and shall be considered sympathetically strictly in accordance with the rules. Fourth, in case the post is available, competent authorities shall pass an order of appointment. Otherwise, the procedure as prescribed in the relevant rules shall be followed, and thereafter the respondent be permitted to join their duties within the time specified. It is also clarified that the appointment already granted by the government, extending the benefit of rehabilitation assistance scheme, shall remain unaffected by the direction as contained herein above. In case the claim of individual respondent is rejected by the authority, they are at liberty to take recourse of law as is permissible. This one is relevant. Direction as issued herein above shall apply mutuus mundus in all pending cases. Aspirants are not required to take recourse until the claim is rejected. Pending writ petition before High Court, if any, shall also be disposed of in accordance with the direction issued above.
So that is what I was asking.
Yes, ma'am.
Just to explain,
the present
what the problem is, this person, he will not be that educated, he will not understand.
My lord.
Again, you please just go back to para B of Supreme Court judgment. Operative portion rather.
My lord, para 5.
B, that ABC what you are reading. Operative portion.
In the case where application has been submitted and any additional document is required to be submitted.
So that issue, that I think the persons who are applying, they are not that, endowed enough to understand that.
Right.
So it is better you make an application afresh.
My lord. I
will
will
say, the only thing is that, but unless you pursue it, he will not understand.
My lord.
You have to tell the person that he has, because the last but one paragraph again read, Supreme Court direction.
In direction issued above shall apply in all pending cases.
All pending cases. So
aspirants are not required to take recourse until the claim is rejected.
Claim is rejected. So last but one paragraph read with B makes it imperative on the part of the applicant to apply. Give the document. So you can. So I'll dispose of.
Yes, my lord. In the light of this judgment,
Jitalo ethi achi? Nahi. Sir, read. Je ki apna aro to ethi samna niya asun. Apne epade pade diyo Mr. Ethi tarku diye. Mr. Sethi?
Yes, Lord.
In terms of Jita Luha, let it be disposed of?
Yes, Lord.
Page 37.
Mr. Samir, appearance lecture. The learned counsel for the petitioner refers to and relies on the judgment rendered by the Honorable Supreme Court in Civil Appeal number 5842 of 2025. Judgment dated
2nd May 2000.
2nd May 2025.
My lord.
Kolondeki, State of Odisha and others versus Jita Luha. And the batch of applications. It is agreement. It is agreed at the bar that the pending application has to be disposed of in terms of paragraph 12 of the state judgment. Also directed by the apex court. The operative portion of the order of the judgment dated in Jita Luha, in State versus Jita Luha, Supra, is reproduced here. The writ application is disposed of. It is further directed, the petitioner, if so advised, can make application afresh along with enclosing all the documents, along with copy of the application filed earlier as annexed to the writ application before the authority as directed by the apex court. They're using the language designated authority. What? Jurisdictional authority. Jurisdictional authority. Language used is jurisdictional authority.
May I pray one thing, my lord? My lord, may director stipulated time period, my lord.
Upon furnishing of the certified copy of this order and further application, if any, the jurisdictional authority. Here he was working under whom?
You are working under OP number 1, my lord. That ward attendant in a college, my lord. Principal Odisha Medical College of Homeopathy.
It is further directed. It is further directed upon furnishing certified copy of this order along with copy of the application to be filed, if any, or copy of the earlier application along with all documents relied upon by the petitioner before the designated authority, OP number 1. The same shall be considered by the said authority or shall be forwarded to the appropriate authority for consideration in terms of the directions issued by the Honorable Supreme Court. The entire exercise shall be completed within a period of 4 months. 4 months from the date of production of the certified copy of this order, along with application, if any, disposed of accordingly.
Please, Your Lordship. Your Lordship, I'm appearing for the opposite party wife, Your Lordship. I pray for an adjournment. I will file the counter, Your Lordship.
Mr. Ashwini Kumar Das for the petitioner. Ms. Jemaiba Sarkar, J. Sarkar for the opposite party. The opposite party, the Law and Counsel for the opposite party submits that counter shall be filed, for which how much further time?
1 week, Your Lordship.
For the 1 week time may be granted. So accordingly, the matter is adjourned to be listed in the week commencing 23-2026.
Obliged.
2 weeks कर दियो. Yes. 1 week or 2 week. Yes. Next, please.
Obliged.
36.
And for the petitioner, I'm filing an affidavit. Okay.
Yes. For table 36, not 35, 36. 36, sorry.
What a copy.
Just give me a moment. I'll just get the file. You file it in the registry so that there is less chance of getting misplaced.
Achha. Okay, I have
Mr. Upendra Kumar Samal for the petitioner, Mr. Bromokesh Tripathi for the opposite party. Learned counsel for the petitioner submits that the petitioner is filing affidavit today. Stuff. The affidavit shall be filed in the registry. The affidavit to be filed in the registry shall be taken on record. Scanned copy be updated. Copy of the affidavit is served on the learned counsel for the opposite party in court today. The opposite party shall have liberty to file response there too, if so advised. List in the week commencing. 9/3/2026.
खाली गोटे affidavit रे गोटे fact खाली एक notice मानुଛି. Before the family court, they have not filed any affidavit showing the income. Under the provision of the RTI, I made an application. They gave me reply. Under this website, the details are available. I downloaded the copy from the website, which shows that the income of the husband, the net salary of the husband is 67,000 some odd.
And you are seeking enhancement from what amount to what amount? Awarded is
7,500.
You want enhancement of?
It is 70,000 I had claimed.
No, right now, what is the expectation? 70,000, I mean, per month.
Per month. It is just an application.
See, he is receiving any amount?
7,000.
Is he receiving that? That's the
Yes, he is receiving.
So Mr. Samal, here you can work out here it's a fit case for mediation. Because you are paying.
Milo. Only
here actually when there is no denial to payment, there is a difficulty in mediation.
7,000
during pendency, you try to use your good offices.
Milo.
You talk to your senior and arrive at amount. If then he will persuade or the court will direct.
My lord, she is staying only 20 days with me, my lord.
So 2 days can be 2 hours, 2 seconds.
My lord.
Sir, if I pass that order, since the opposite party has stayed only for 20 days, the amount cannot exceed 7,000.
My lord.
So then Mr. Das, they will laugh at me and they will go to Supreme Court and say that he doesn't understand the law. You must make a submission to bolster my order.
My lord.
Legally sustainable order I have to. That is a factor for granting permanent alimony.
My lord.
But for day-to-day life, how could you apply the test? The total period of stay was directed by that is observation. I think you are referring to that, but the total period of stay as referred in Rajneesh versus Neha.
My lord, and she was a high qualified also. My lord, she was the education qualification BTech. My lord.
125 rate, 124 rate. All those considerations are not that material.
My lord.
Through the honorable court, I only pray, let my learned friend be fair to say what is exactly the present salary is. That is the only. Because the trial court.
So you talk to the person.
Yes.
Mediation go down.
Mediation problem is I am requesting you to mediate.
My lord, actually what happened, my lord, husband.
He's an unwilling customer to pay. Please appreciate that. And law has sufficient, there is sufficient, provision in law to make the payment to the wife.
Well, we are ready to pay, my lord.
What is the usual defense? What is the usual defense in case of allegation of voluntary desertion?
My lord.
What is the usual defense?
My lord, କିଛି ନାହିଁ ସେ ଶାଶୁ ଶ୍ୱଶୁର ପାଖରେ ରହିବେନି.
ଠିକ ଅଛି ଶାଶୁ ରଖିବା ପାଇଁ ଆପଣ ତ ସ୍ୱାମୀଙ୍କ ପାଖରେ ରହିବା ପାଇଁ ଚାହୁଁଛନ୍ତି.
ସ୍ୱାମୀ ପାଖରେ ବି my lord ଯେତେବେଳେ
ଆପଣ ସେ ଯୋଉ ପ୍ଲିର କିଛି ମାନେ ନାହିଁ.
My lord, when she was staying
when you allege voluntary desertion.
No, my lord, what happened, my lord?
No, my lord, ଆପଣଙ୍କର ଫେଭରରେ ଯୋଉଟା ସେଟା no, my lord କେମିତି କହିବେ? ଆପଣ ହଜବେଣ୍ଡଙ୍କ ପାଇଁ ନା ୱାଇଫଙ୍କ ପାଇଁ?
ମୋ husband ପାଇଁ.
ତାହେଲେ voluntary desertion ଆପଣ no, my lord ପାଇଁ?
No, my lord, actually what happened?
When the husband alleges voluntary desertion by the wife for no suitable cause or no just and proper cause. There the usual defense is the wife said that the situation is so that I cannot stay together. So you must understand what you are arguing. So you never know what is there. So prima facie, the court cannot arrive at a conclusion that there is voluntary. It's a matter of evidence on record.
My lord.
Pleadings, complete pleadings, evidence, and then you can prove rejection.
My lord.
Specific finding by the learned trial court that it is not a voluntary desert, sir.
No, no. So then I have understood a little correctly also then.
Yes.
Then that's a matter of actually
Only
fact to be
learned-
proven before the court. So the point is that if you can work out, she may not be happy. You come forward few steps ahead, and rest you talk to Mr. Samal. Then he will he will talk to the lady.
My lord.
So that much effort you can make. I am not observing anything that way.
My lord.
Yes.
Can I
This is 125.
120.
120.
And then you have to show the person 125.3 is there, 126 is there. He must understand the rigors of law also. They are staying it themselves. Last take on yes. Already date is given. Yes.
Can I pray my learned friend to be very fair enough to say
No,
provide the
sir, he is fair. He is fair, no doubt about it. But you understand what the approach of usual approach of husband in this kind of a proceeding. They are not listening to the lawyer.
let both of us file our assets and liabilities affidavit before this honorable court.
No,
It is a continuation of the so
correct, but to arrive at that interim figure, it is not necessary. So that is how
it is
my
a final-
purpose of asking you for allowing 7,000 maintenance or 10,000 maintenance. One need not go into these details of analyzing the assistance liability. You see, nowadays what is happening? They are taking the pleas in one matter, 8 lakhs. I have taken bank loan and hand loan from Mr. So and so. Say Mr. Tripathi. It is filed in court. In debt servicing, I am
assets and liabilities affidavit, which is a mandatory requirement. Assets and liabilities affidavit, which is a mandatory requirement. Even if that mistake has been committed by the learned trial court, in a appeal is a continuation of this.
But Mr. Someone, it is very difficult to. You can carry the horse to the coast. Cannot make it drink water. It's a problem. If you go for all this deliberation in 125, because that paragraph can be read like that. That in all proceeding, asset liability should be there.
Yes.
It becomes very difficult. The proceeding becomes lengthy. But to arrive at a 13 petition is pending.
No other proceeding. No other proceeding.
So hopefully they will reunite.
My lord.
Hopefully.
ସେଇଟା ହେଲେ say
Let us see.
My lord.
say asset liability both side asset liabilities ଟା ଦିଅ.
ଚେଷ୍ଟା କରନ୍ତୁ.
My lord.
Yes.
ନାଇଁ ଯେ ଗୋଟେ
My lord, we are
ଆଜି ନୁହଁ ତାକୁ ଆଜି ଟିକେ leave ଦିଅନ୍ତୁ. At least he is a compliant person. He is paying you 7,000. Yes, next.
ସେ ଦଉଛନ୍ତି ସେ
Yes.
37.
Obliged.
37 my lord.
Mr. Jayadeva Behra for the petitioner. Your name, sir?
My Sashwat Kumar Sethi on behalf of Mr.
Sashwat, you are writing SK.
My full name, Sashwat.
Full name, Sashwat Kumar Sethi on behalf of Amitabh Tripathi for the opposite party. Yes.
Here, my lord, the petitioner challenge the order dated 36/2025 passed by the Learned Judge Family Court Nayagada in CLMP number 182 of 2022 to pay the wife a sum of rupees 3,000 and OP number 1 and 2,000 to the OP number 2, the wife, my lord.
Both wives together or wife and child?
Wife and child.
You said wife price, 2 times. OP number 1 wife and OP number 2 wife.
No.
OP number 2 is the daughter.
Daughter,
man.
Daughter aged?
Aged about
2 years.
2 years.
2 years. My lord, there is first ground there is no such marriage in the categorical court below. In object that in conclusion page 19 conclusion finding on
ପୁରାଟା ପଢିବେନି ଆପଣଙ୍କ ଏଭିଡେନ୍ସ ଗୁଡାକ ଯାଆନ୍ତୁ.
ଆଜ୍ଞା.
You are the defendant before the trial court.
Defendant.
It is a continuation.
ଆଜ୍ଞା.
So you show your evidence shown to the trial court denying your liability.
Yes, madam.
Denying your capacity, all these things. This is a matter of evidence.
Yes.
You show that.
There is no such marriage. They have stated the loan code below to marriage on both the 15/9/2019 at Dakhinakali.
Mr. Behra, suppose in the marriage you are not invited, the judge is not invited. So can that be inference? that since we were not invited to the marriage, so it's a matter of evidence.
Yes, my lord.
So
Yes,
he's
sir.
saying that I never married. So how can the court will go into that unless you prove that?
Yes, my lord. I prove like the mal can see annexure 2 my lord.
Annexure nahi, annexure nahi. Apna कोटा exhibit 1, 2, 3, 4 documentary exhibit सेवड़ा देखंतु. इटा कौन read नहीं लगे. इटा this is not read petition. I have to go to the basic evidence.
My lord.
Apna annexure देरो, Mr. Sethi will now file annexure. Both of you will go on competing with filing annexures. The court is at loss.
There is no such marriage, my lord.
Sir, how have you proved that, sir? Your point is well taken. That is why I am not
Yes,
understanding.
my lord.
What was the material to show that there is no? Because you see, you are the defendant there. You filed a written statement.
Yes, my lord.
Suppose you say that the wife is not existing. Let us assume non-existent person, much less she having a child. So who will prove that?
The husband, lord.
Obviously, the defendant has to prove that. So how you have done that, and where the court erred in analyzing the evidence?
My lord, this is the fact. Can I see the annexure 2, my lord? This is the
Annexure फेरे गले sir.
paragraph 19 the
And kindly look at page 29 of your brief.
content. Yes, yes, my lord.
So kindly look at, read it. List of. You are getting page 29 of your brief, internal page 17 of the judgment.
Again, 17. List of witness examined by the petitioner and
petitioner, PW1, PW2, PW3. Then
list of examined by the opposite partner only Vikram Pradhan, OP number.
Then exhibits.
Exhibit A, Xerox copy of Mamata card and
FIR, Mamata card.
Yeah. 2 net copy of.
So that is copies khata means that is a record of right. Then kindly mark list of exhibits marked by the opposite party. List of exhibits marked by opposite party.
How? They have exhibit the nil.
Nil. So now I add 4 or 5 exhibits. Annexure 1, Annexure 2, Annexure 3. Can I? I cannot. So first of all, you have to get over statement of PW1, 2, 3. Their cross-examination.
Yes, ma'am.
Then what you have stated and your cross-examination. Then the document. Especially the Mamata card.
Mamata card, ma'am.
Whatever.
Mamata card regarding the birth of the.
So now, yes. So if you get over that, then there can be a case of remand also. Or you are successful in proving that there is no marriage, convince the trial court, appellate court. Everything, all the statements. Whether you have dislodged the statements made by the PWs by cross-examining them. Right. Now, suppose you start reading the evidence. You cannot, it's not possible to address now. You cannot prepare now and look at the evidence again and just now at your hand. You have to go through to formulate and gather your thoughts to address the court. If at all there is any ground, which should have been done before filing the petition.
Regarding the date of birth, the present petition also, the Mamata card regarding the birth of the child.
Sir, what was your argument based on that? What was the statement or cross-examination on that? Who adduced that? What is the finding? Those 3 things you have to say, relying on the materials before the trial court, that the trial court erred. So what do you want?
Another paper. Another paper.
Mr. Joydev, little appearance. The learned counsel for the petitioner was heard at some length. He has adjournment to examine the materials on record before the learned trial court. To address this court in the present proceeding in the form of appeal. The revision.
Revision.
Is a revision. Revision. Yes, next please. Date करो तो अपन रह गए. Listing the week commencing 23/3/2026. Yes. Next. Mr. Chitranjan Sahu for the petitioner, Mr. Ashwini Kumar Das for the opposite party. Yes.
This case,
Yes, you are seeking adjournment for what?
my lord, the party will argue the matter. That's why.
Okay. Sorry, not.
The party will argue the matter, my lord.
Party will argue the
Yes.
matter. Arey, no, they cannot, sir. I have really struggled to find somebody.
Why I permission, my lord?
I have, Mr. Sahu, whatever little experience I have seen on that side.
Admitted, my lord.
I am yet to find a person who understands what he is arguing in person. Even in service matter, what is the perception is, because he is himself, he has an educated person. He is serving as a officer or at least class 2 or group C. Group C may not be, but I have seen people, they do not understand what they argue.
Because my difficulties also kindly see. Because here, one of the advocate, my lord, he is creating all sorts, my lord. And she is, something is there. And as per instructions, my lord, I am allowed to serve
How can the trial court, you or Mr. Das, any of us, we cannot delve into those things. So those are, these are so complicated, things are getting so complicated.
Let the last chance given, my lord. If not, I will do the matter, my lord.
Don't encourage, they don't understand what is the point. Sir, it is so difficult for a lawyer to understand.
That way, I will
For a judge to understand.
I will present, my lord. If not, I will argue the matter, my lord. Let a chance, my lord. They need that lordships.
Is adjournment. The problem is, since September, the order passed. Respondent is not getting a single pie.
State.
Not state. No state. No state.
Give them a chance. You work out a solution.
I don't have to say anything.
You also use your good offices. This doesn't work this way. To persuade both parties.
A circumstance the petitioner is alone, the respondent is alone. No issue, nothing. Even they don't have relations also. Respondent, those two brothers, they have all expired. And this lady is in a very tough position as financial condition is concerned. She was surviving with this money. However, from September, they are not paying a single pie. It's more what adjournment mediation. After 12 years, allegation gone.
I am
Nothing is progressing. Perhaps not possible also. Because what the mediator will ask.
Simple.
Mediator cannot tell you that. Suppose you agree for a lesser amount.
I don't like 13 times she did not come to the court, not meet me, my lord.
Nothing that we
No, I am paying, my lord. All things are paying, my lord. This is my last payment, my lord. 11th I payment, my lord.
I get it.
My lord.
If that is so,
my lord.
That is his instruction, Mr. Nas's instruction. So he goes by, you are saying that, I am not saying, I am not passing any adverse order. I told you. Why I said that you make an effort. So they don't understand what they will ask.
what a chota jinsa say, he was not paying a single pie, order lapare. Then it was written to Naval Office. Naval Office to direction asla court to. Repent it was the direction, court direction bank account bank account to 10,000 deduct karo. It was the condition. Set up on the period September he has not paid a single pie. That too on that issue only. The account to directly deduct hotala. This was the circumstance.
I am ready, my lord. Yes, because pending for ships. No, all the area amount is no, my lord. All the area amount is from my pension, my lord. As per the court order.
That is the instruction, but you take obtain instruction on that. But they are not directing or observing. If they say that I have dictated order, since you are trading and all this, you obtain instruction on that. That will help your client also. Instead of taking
The handicap person, lordship, that's difficulties.
The government party comes that additional was without the maintenance being paid, as are directly being paid. There are now for the business of the instruction. This understanding of law is such a subject. To apparently say that everyone understands it's very difficult to. And more so when they have to do this maintenance and financial assistance, Act of Section 24.
Yes, suppressing some things, lordship, that I am specifically said, my lord, in September.
No, kitchen, no other petition. Nothing. Kitchen. It कौन है लगे?
Such like that, money for 13 or 9 or any 198, all those things start.
kitchen कौन सा petition है? Nothing is left.
Now, again, why the degree cases are fine.
No.
These things are the law. Anyway, so this is the recommendation.
नहीं ठीक है 23-24 दिन है ता परगो जाओ ये टाइम जाओ नौ 3 ठीक है ठीक है 39
I am for the opposite party. A copy of the counter affidavit I have already served upon him. I cannot file the same. I shall file it.
Right. Mr. Vibhuti Bhushan Swami for the opposite party. It is submitted by the Land Council for the opposite party that copy of the counter has been served on the Land Council for the petitioner, and the same shall be served on the same shall be filed in the registry during course of the day. Stop. The counter shall be taken on record. Scanned copy be updated. List in the week commencing 23-20-26. Yes, please.
Yes, my lord, I am seeking transfer proceeding from Judge Family Court Bhubaneswar to Puri, my lord.
Mr. Das, now you should mediate. Can you not agree for a transfer, or what is the difficulty?
The difficulty husband belongs to Balianta and the wife belongs to
Chandanpur.
So Bhubaneswar is the middle place. So there will be no inconvenience for attending the court from both the sides at Bhubaneswar. Rather, from Balianta to Puri, husband will be pressurized. One thing. Another thing is husband apprehends something on the doorstep itself. Husband has to pass every dates.
No difficulty.
There may be some apprehension.
Apprehension can be basis of transferring. Problem is that the court enters into a very difficult arena. There has to be real-time threat or real something that would have happened, or some FIR or something, because the court is the trial court.
Yes.
The trial court.
Bhubaneswar is the middle place.
Bhubaneswar actually the middle place. Balianta Puri, now there is a direct connection.
Nice to Bhubaneswar now. Bhubaneswar is why
upon the Tokopay road, Chakra Otki, Bone Court, Jibe, all that polling.
Tokopay Chakal, Bhubaneswar, Bhubaneswar is Purijibe. See,
My instruction is that I have no sufficient income. And my lord, the distance is about 60 kilometers. I have to travel from Puri to Bhubaneswar. I'm no male person to accompany me.
ବର୍ତ୍ତମାନ କୋର୍ଟ ଆପଣ ଚାହୁଁଛନ୍ତି ଭୁବନେଶ୍ୱରରୁ ପୁରୀ
Puri, Puri.
ଆପଣ ଚାହୁଁଛନ୍ତି
ଆମେ ଭୁବନେଶ୍ୱରରେ ରହୁ
ଭୁବନେଶ୍ୱରରେ ରହୁଛୁ
ହଁ ନହେଲେ ପିପିଲି ହେଲେ ବି ହବ ଯେ
People କୋଟି କୋର୍ଟ ଅଛି।
କୋର୍ଟ ତାହେଲେ ଭୁବନେଶ୍ୱର ରହିଲେ ହଁ
ପୁରୀ ଠିକ ଅଛି ନେଇଯାଆନ୍ତୁ ସେ କୋର୍ଟ ପ୍ରୋସିଡ୍ କରନ୍ତୁ ତାପରେ advantage ଆଉ ଗୋଟେ ମିଷ୍ଟର I mean Das Mahapatra is that Bhubaneswar court is overburdened. Three courts overburdened and
taken some wrong thing. ତାଙ୍କର ଭାଇ ଅଛନ୍ତି ବାପା ଅଛନ୍ତି ତାଙ୍କର ବିଜନେସ ଚାଲିଛି ଏଭରିଥିଙ୍ଗ ନା ମୋର କେହି ନାହାନ୍ତି କହିବାଟା ଇଟ ଇଜ innocent also.
ତ ସେଇଟା ତ ଇଟ୍ସ a matter again you are asking the court to enter into very difficult terrain.
ଏସବୁ ଜିନିଷ ଆଉ ତାପରେ
ଆପଣଙ୍କର difficulty ତ କିଛି ନାହିଁ
difficult ହଉଛି ଏଇଟା ଯୋଉ ତାଙ୍କ ସେ ଫାଷ୍ଟ ମ୍ୟାରେଜ କରିବି
ଆପଣଙ୍କର ତାପରେ if you have all ICT initiatives ଆପଣ ଭୁବନେଶ୍ୱର appear କରନ୍ତୁ ପୁରୀ କେସରେ
ଆଜ୍ଞା
ଆରେ information and communication technology ରେ ବର୍ତ୍ତମାନ everywhere it is available you appear
ଭିସିରେ appear କରିକି
ନାଇଁ ଭିସି ରେ ତ ଆପଣ ଡିପୋଜ କରିପାରିବେନି ଅଛି ତାର ଅଛି ଗୋଟେ ପୁରା ଅଛି ଲୟର ମାନେ ସେଟା appear କରୁଛନ୍ତି ବଟ୍ କୋର୍ଟରେ ଯୋଉ ଅଛି ଆପଣଙ୍କର
ସକାଳ ଦିନ କଥା ହଉଥିଲୁ ଏଠି ମିଡିଏସନ ଗଲେ ଏଇଠି ଯଦି କ୍ଲୋଜ ହେଇଯାନ୍ତି ଦିଶୁର ଦାଟୁ ଆମେ ମଧ୍ୟ ରାଜି ହେଇଯାନ୍ତୁ କିଛି ନାହିଁ
ମାନେ 13 ନା 9 ନା
13 ଏଇଠି ଯଦି ରାଜି ହେଲେ ହେଲେ ବି ହେଇଯାନ୍ତା କାହିଁକି ଆଉ ସେଠିକି ଯିବା ଆସିବା
ଯିବେ ଠିକ ଅଛି ମିଷ୍ଟର ଅଭିଳାଷ appearance lecture Mr. Abhilash Mishra for the petitioner, Mr. Raghunath Das Mahapatra for the opposite party. The petitioner, wife in the marriage, is before this court seeking transfer of the 150. Sorry,
31.
No, just 1 second. I have opened another brief. In transfer of CP number 579 of 2025, putting before the learned judge Family Court Bhubaneswar to the learned judge Family Court Puri. Stop the said the said CP filed before the Honorable Judge Family Court Bhubaneswar has been filed by the opposite party husband in the marriage under section 13 into bracket 1 into bracket 1A of the Hindu Marriage Act 1955, seeking divorce, dissolution.
Divorce, yes.
Seeking the dissolution of the marriage solemnized between the parties. So, having had learned counsel for the parties, apparently there is a hope for mediation and hope for the parties agreeing for amicable settlement and reuniting to resume the matrimony. Accordingly, the matter shall be is referred to be placed for mediation before the court annexed mediation center. Stop. The record shall be placed before the coordinated mediation center, Orissa High Court. The learned counsel for the parties are requested to approach the coordinated mediation center on any date
ଆପଣ ଫିକ୍ସ କର ତାପରେ ଦେଖିବାକୁ
ଆଜି ହଉଛି
ଦୁଇ
on 9/2/2026 on the said date the date of mediation shall be fixed. The parties shall be intimated regarding the next date also. List in the week commencing 13th of April, 20th of April 2024.
26
on the said date mediation report interim report shall be placed for consideration.
Interim order to continue.
Interim order as passed earlier, it 9/9/25.
My lord.
9/9/25 shall continue till the next date of hearing.
I beg pardon, my lord. Item
So, 39 ने दिलीप दीपक कुमार साहू कर
Again.
for the petition. काउंटर पाइछन्ती आपण तो कहले से काउंटर देलेनी मिस्टर सोई एबे अछन्ती से सार का बेसिक केस गेले ना जानि पर नांती कोठे को काउंटर कोन होउची से यस पास ओवर सॉरी